yourself a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is here to help you out with your legal problems. 1300 222 774. And I've got a couple of lines free here, so do join in and we'll try and get to your problems as quickly as we can. David, good morning.
Good morning, Virginia.
Any issues to get to from last week?
Well, we had Katrina rang from Northern Victoria. She did tell us the town, but it's easier not to. Katrina has been her dad's carer for the last 10 years, living in his home, and he's now confused and is likely need to go into care. So, and the question is that the property has been Katrina's home for the last 10 years and she's been receiving a carer's payment. And so her worry was the house going to be sold under her in order to meet the cost of Dad's care? And the answer is no. But Dad doesn't have a power of attorney, so there's a whole series of other decisions. So from Katrina's point of view, the house in which she lives and has lived with Dad for the last 10 years will not be included as an asset for determining the cost of moving Dad into care, which is a positive. But what Katrina needs to do is apply to VCAT to be appointed her father's administrator because she's an only child and the logical person to look after Dad, and then get VCATs. You can then go to VCAT and say, I've got this job, I need an opinion. Is it appropriate for me to continue to remain in the house? And that then means that there's no conflict between Katrina's role as an administrator and her role as Dad's carer for the last 10 years.
Okay, thank you.
So there's some positives for her.
Good, thanks for clarifying that. Roy and Glenroy, you're first up. Good morning.
G'day, how are you?
Well, thank you.
All right. I had reason to fill out a form recently, and you fill in your details, your name, and it said title, Mr., Mrs., Ms. But there was also Brigadier, Your Excellency. Also, is there any offence in choosing any of those?
If the answer that you put is relevant for whatever benefits you might receive, so if you're looking to get an advantage out of it, the answer would be there's probably an offence. If you're just being civilly disobedient, the answer is no.
Okay.
All right. So your question is, why do they collect the information, particularly as the trend now is not to collect titles? If you may or may not have been aware, but a million years ago they used to put, if you were a judge, it actually said that on your driver's licence.
Oh, yeah.
Driver's licences no longer have any titles on them.
Yes, I see.
So
Roy, you're okay.
Roy is not providing false information if he says he's a brigadier when he's not a brigadier?
The answer is that he is, but the question is it information that's important in terms of the form you're filling out?
Roy, are you a brigadier?
No.
Just thought I'd check that.
Yeah.
So
if I call myself professor or something like that, how does that go?
Well, you come back to exactly the same question.
Yeah,
why are you doing it? I mean, I'd be coming along and saying it's information they don't need.
Yeah, okay.
Yes, yep.
So there's no fine for being a smart aleck, Roy?
Well, that's great. That's terrific news.
So are you going to put down brigadier next time you fill in such a form?
I may very well, yes.
May I ask you why?
Well, it's a bit of a laugh.
Rightio. Thanks, Roy.
Thanks a lot. Bye-bye.
Thanks for calling in. Someone's having fun. Julie in Black Rock, good morning.
Oh, good morning, David, and good morning, Virginia.
Morning.
Sorry, a bit nervous.
That's all right.
It's a fence issue. We've got an older style apartment block, probably built in the 30s. There's 5 apartments. And in about 1979, there was a subdivision of the title. So on one side, we've got 2 on the ground floor, 2 on the first floor, and the other side we've got a apartment that has first...
A standalone building. Is that right?
Yeah, but David, it's joined. The bricks, like it's only separated by a fence and the subdivision, common roof, body corporate. We're all in the body corporate.
Yes.
And there's a paling fence between the single owners and the 4 owners, and it's been there for a long time. I purchased mine in 2002. It fell down at one stage and was re-erected in the same spot, but it was there, still there. The people who have recently purchased next to us have had surveyor, and they say that that fence is in the wrong place.
Mm-hmm.
So we were wondering, sorry, trying to be quick, we were wondering, is there a situation of adverse possession relevant to owners in a body corporate strata property? The fence has been there for a long time.
There is, but it's kind of difficult. It's very difficult to be in adverse possession of something you already own a share of. But it is possible for there to be an adverse possession claim made in respect of body corporate property where one of the owners is claiming that they've kept a courtyard or something like that. So it is possible.
Okay, it seems like what the surveyor, recent surveying that's been done by our neighbour and the surveying that was done at the subdivision, from what we've been able to discover, they are the same, and that when the subdivision happened there wasn't a fence. But I'm not just not quite sure what we should do.
How much land are we talking about, Julie?
Probably not a lot, David. I think he said it's 1.4 metres at the fence line and 1.4 and 400 centimetres at the front of the building. So it's like a wedge shape. I mean,
you need to decide whether someone wants to run the argument. I would have thought that in one sense, it depends upon which way the fence is to move. But I would have thought that the standalone unit or the unit on the other side, your four, would probably have a reasonable claim for adverse possession. So why don't you come along and work out? In one view, they recently bought the property, and in one view, that they thought they were buying what was inside their fence line, rather than what was. So you're a small community of 5. Why don't you try and work out what the right answer is, and work out where collectively you would like to see the fence erected?
Julie, we'll leave you to figure that out, and thank you for calling in. Your line's a little bit wobbly there, David. I don't know if you're able to move
Stand
slightly.
up a little? Yeah, okay. I'll lift one leg up, okay?
Lifting one leg up always helps, I find,
yes.
So thank you for doing that. Angela in Doncaster East, how can we help you? Good morning.
Oh, good morning, Virginia and David. Thank you for taking my call. I'd like to know what are the legal implications of ignoring a building order issued by a council.
Can I ask the nature of the building order?
Regarding cladding on our building that was built in 2014.
Is it flammable cladding, is it?
Yep.
Ooh.
And so you've got an order from the council to fix the problem and the owners' corporation hasn't or won't, is that right?
We've been trying for 3 years to get information from council and the VBA about what we need to do. Nobody will reply to us. They finger point at each other.
Has the owners' corporation obtained a consultant's report as to what's wrong and what needs to be done?
No.
Because it's inconsistent.
Hang on, we just need to hear from you or the person who knows. Yeah.
Yep. There are inconsistencies in the report. They tell us that we have 23 sole occupancy units when we don't. We have 21. They tell us that we are a 4-storey building with a basement when we're not. We are 3 stories and a basement. It's just...
Do you have an order requiring you to fix the cladding?
We do. Yes, I'm sorry. Yes, we do.
Then you need to comply with the terms of the order, and that may involve obtaining additional time in which to comply with the terms of the order. It may be that if you're not satisfied with the action being taken by the owners' corporation in relation to the building notice, then you can take the owners' corporation to VCAT on the owners' corporation list to endeavour to resolve that. But I do think it's whether it's 3 stories or 4 stories in a basement, and whether it's 21 units or 23 units, it's the same building, it's in the same location, and it's got a cladding issue.
Yeah.
So
We have
I
no
think to
problems
pick
with-
the experts' report on the basis that they haven't counted the number of units correctly doesn't sort of solve your problem.
No, we have no problems with the Owners Corporation. They've been very supportive of us. They've been fantastic, in actual fact. Everybody has been trying to get us onto the CSV register, Cladding Safety Victoria register, and apparently we can't get on it.
But
Why not?
Angela,
Is your
can I-
building too small?
We don't know why not. Nobody will tell us why not.
Angela,
That's
if you have a
frustrating.
building that's clad in dangerous flammable cladding, do you not want to, as a matter of urgency for your tenants, want to fix that as soon as possible so that you don't have a building that goes up in flames?
Yes, we do, but we don't want to pay for it. This building was built before the state government changed the legislation,
But you
and that's
So-
the crux of it.
The issue, Virginia, if they can get on the government list, then there's some financial support available for the
Exactly,
work to be done.
exactly. And no one will put us on to the CSV register.
and are you
Oh, well,
are you
let's
told
take it
why?
as homework then, all right? So that I'll come back and see, I'll read the requirements for getting on the register and see if I can assist you.
In the
We'd
meantime,
love
Angela,
to
have you
know
been
what
told
the
why?
criteria is to get onto the register, because no one will supply it to us. We would love to know that criteria.
I'll
Okay.
see if I can find it for next week.
All right. Well, that's some homework for next week, and we might see if we can look into that a little bit here on the program as well, because that's still an ongoing issue, as you know, David, for a number of buildings around town. Jeanette in Albert Park, good morning. How can we help?
Oh, good morning. Thanks for the program. My question's about does a body, an owners corporation, have a duty of care in managing COVID infection risks, and specifically around QR codes or non-residents using common property, and quite particularly there's a very large letterbox outside a bathroom, and there's negative pressure, meaning that when people congregate and get their mail, that air from that group of people just gets sucked back into the bathroom, and it's going to be hard to change the physics of that situation. So I'm just wondering, can we exclude people? Can we put up QR codes? Can we move a letterbox? What's the process to make the place safe? And if we don't, what's our obligation?
The body corp will have obligations as the occupier of land. And it's really a question of looking at, have you had a look at any of the government gazettes relating to COVID requirements?
No, but thank you for the
Because
direction.
that's where you start.
Yeah.
Gazette.vic.gov.au.
Yes.
And you can, there's a bit of trawling that you'll require, but you need to look and see whether the premises that you're describing are described as whether they're private or accessible to the public, and it will give you some indication as to what congregation is allowed.
Thank you.
So that's where you'll find the rules.
Okay, and I hope that's helpful to you. Thanks so much. David in East Brighton, what's happening in your neck of the woods? Good morning.
Yes, good morning. Thanks for taking the call.
That's all right.
We're having a dispute with council about damage caused by roots of trees. We've got beautiful trees in the street. First issue was maybe 5 years ago when our water main was damaged, and then more recently we discovered that a stormwater outlet was blocked by roots from the trees. And I spoke to council over the last couple of years, and in the end did all the work myself because they told me I could claim afterwards, maybe. And I've sent in the claim, and I got a response from an advisor they used, which said the claim was rejected firstly because they only became aware of the problem on the date that I submitted the claim, which is patently untrue. And second of all, because they referred to a court case in New South Wales, New South Wales Court of Appeal, the Owners Strata Plan number versus Wallara Municipal Council, which said that the council is not liable for tree root damage to property it was not previously aware of. Well, the first thing I was wondering was, I've got limited understanding of the law. Does the law that was, or a court decision in New South Wales, does that apply in Victoria? And second of all, what sort of argument is it to make they weren't aware of the problem until the date that I lodged the claim? And in fact, they're doing major street works now in the street over 3 months, doing work to mitigate damage caused by the tree roots.
Right. The first one is that the our legal system operates on what's called precedent. Has a judge administering or trying to interpret a similar fact situation anywhere else come to a conclusion, and based on what? And so that's where we get the case that you're talking about.
Yep.
And so the issue there was, well, tree roots, who's responsible for them? And and my view is that the council will have properly interpreted the law as it understands it to be. The other thing that you might like to look at is there's a piece of legislation called the Road Management Act, which talks about the council's obligations and responsibilities for the road, including not just the pavement, but the road reserve and the footpath and all that stuff.
Yep.
So there might be something in there that you could look at. But I would be going back to council and pointing out to them, there's two parts to this. You can tell them what the problem is, and then if they invite you to do the work and seek reimbursement, then you're entitled to it. You're entitled to seek it. Whether or not you'll get it's a different.
Yeah, they never guarantee I'd get it, but they said I could claim. Yep.
Yes, right. Otherwise, you do. What's happened is that the report that you've made has encouraged council to deal with other issues in the same street. So it's not in the least bit satisfactory. If you think that the council's property is causing you damage and you don't get the response you want from council, then the group that you talk to is the Ombudsman's Office.
Okay. All right. Thanks, David.
Hope that works. Thanks so much. Perry in St Kilda West, what's going on? Can we help?
Morning, Victoria and David.
It's Virginia.
Yes,
thanks, Perry.
I was married to a man for a long, long time, and we separated but not divorced, and he went to live in Perth a number of years ago and had a partner. Very sadly, he died in Perth last year after a very short illness, and that was very tricky to manage in that awful COVID time. So amongst all of that shock and surprise and, great angst, I've got 3 adult children with him. He'd made a will a number of years ago where his partner was both the executor and the sole beneficiary, which was a bit of a shock because we actually, all got on quite well. After this, my children and I reached out to her, wondering about the will and the absence of a legacy to his kids. And in a couple of emails, she promised that she would arrange, because he was supposed to live a long life and enjoy whatever he had to live a long life, but 66.
Yeah.
She'd promised that she would arrange his estate to be given to the children, but it would take time. Now we know, which I understand, we did a probate search and we know that probate was granted in February in Perth. And my question is, I understand that there's like a 6 months limit.
No, Perry. He died in Western Australia.
Yes.
His and presumably all of his assets were in Western Australia.
Yes.
His obligations are under Western Australian law.
Mm-hmm.
Now, I know, for example, that we have a 6-month period in Victoria that claims need to be made within 6 months of the grant of probate, but for Tasmania, for example, it's 3 months.
Okay.
So you actually need to visit a web, have a look and do some online searching, find out what the situation is and get some advice from somebody in Western Australia.
Okay. Yep. Okay.
Right? Because that limitation period is important, and even if you, although this is a slightly different question, the other thing that you need to ask, Perry, is whether or not your husband had a moral obligation to provide for his children, and you also need to take into account the extent to which they're able to provide for themselves. So there's no guarantee that an application would be successable. And
no, we understand
3 children.
that, and very much hoping that, how we have in writing, I think it's now we're up to about 3 sort of written evidence where his partner has
She basically said it will be fine. Yes, that doesn't get you where you want to go, I'm afraid, Perry. The issue is, under Victorian law, that would be meaningless.
All right, so we'll have to go and find out, or you'll have to go and find out the Western Australian situation. David, just on that front, are the laws covering probate and what happens with people's wills, are they distinctly different state to state in Australia?
There are fiddles around the edges.
Yep.
But in terms of, and it may, so for example, in Victoria, we have a list of categories of people who are eligible to claim, and if you're not in the list, you can't claim. Other states are slightly different, have different limitation periods and different sets of rules about what the court will take into account in determining whether you can make a claim or not.
But issue your children, that would consistently be recognised by courts around the country as people entitled to make a bit of a claim against an estate, I would imagine.
Entitled to make a claim, yes, but whether so for example, we've got two interesting provisions under Victorian law, one of which is that I don't need to provide for my children to the extent that they can look after themselves. And there's a social policy one that says that in determining whether they have the ability to look after themselves, you have to ignore any government benefits they might be entitled to.
I think we can just quickly fit in Michelle from Preston before we wrap up for this morning. And we're hearing that at 10:45, the Premier, Daniel Andrews, the Minister for Health, Martin Foley, Brett Sutton, the Chief Health Officer, the whole lot today, and the COVID-19 Commander, all four of them, Juro and Weimar, will be speaking to you at 10:45. We will bring that to you live. You can also watch it live as we stream it on our ABC Radio Melbourne Facebook page. So stay tuned for that, and that'll be the details of our way out of this lockdown. But Michelle in Preston, we can get to you quickly. Hello.
Hi, Virginia and David. Thanks for taking my call. My mother recently moved into an aged care facility. She's of sound mind. She instructed that her car be sold, and there's 3 siblings, 3 children. One of my siblings took the car and refuses to return it, despite numerous requests. What avenues do we have to compel that sibling to return the car?
Well, return it to where now that your mum's moved into care?
She still has her residential home.
Okay, and does she have an attorney?
Yes.
And is that the attorney, the person who's got the car?
It's a joint power of attorney, and the 3 of us hold it. And
so every action requires all 3 of you, does it?
Yes.
Then the issue is that, in a sense,
well, actually, technically, it's 2 of us can make the decision. 2 of us can make decisions of the 3.
So yes, by majority. So there are 3 attorneys appointed, 2 by majority. Then the 2 who want the car removed have the right. You have no right to trespass to recover it, but you do have the right, if you should need to issue proceedings for its recovery.
Okay. And that will be done through
Magistrates' Court, unfortunately. Yes.
Yeah,
okay. No, I don't want to head down that path, but unfortunately, it's not ending up well.
No.
Might have to be something you just walk away from.
What's the car worth, Michelle?
It's a Mercedes 2008. We've looked at the value's about $12,000.
Okay.
But it was,
you need to decide whether it's worth pursuing.
Yeah. It was the express wish of my mother, who I said is of sound mind, for the car to be sold because she knew there would be issues around it.
As there clearly are. Michelle, the Magistrates' Court is where you need to go.
Yep, if you want to try and recover it, and that's difficult. We can hear it in your voice, and of course it would be for any family. David, always great to get your advice. We've got some homework for next week. We'll see you then.
Thanks, Virginia.
David Whiting there, Melbourne solicitor.